Yes. Item number 15 was not fixed. It's come up suddenly. But I have made a request to sir. Can it be taken up after the vacations? On the prayer of Mr. I chose learning. Then looking there and prayer not being objected by Mr. Arsenio, then concept in the case that this method be listed on 27, 10, 20. Right. It's fixed date today. What was the last order? After 4 weeks, 3 weeks. Very, very frank. I mean, unless it is unavoidable, difficult to adjourn the matter. And there's a notification for filing what is called adjournment slip. Why don't you that?
Nothing but 14 I'm appearing as an amicus. They are like on this Adjournment 13. This level council is from Guwahati. Because of some personal difficulty, probably in today. And after vacation,
Only around that Mr. BK Mahajan. BK Das or BK Mahajan? Where is his name? He is a senior counsel. BK Mahajan. Senior counsel. Anyway. MS M. Karba, London Council, hearing on behalf of Connect. Submits that in these matters, in this criminal appeal, Mr. BK Mahajan, the English, our yes, some question, and praise for listing of the matter. After 4 weeks, Mr. H. Lampo, London, prayer for adjournment is accepted. I agree. But is let this matter be listed on very simple. 10, 20. Yes.
so I beg to mention
Item 11.
Yes, Mercy. Conducting Council Mr. R.S. Mishra. You got this.
His name is not there. R.S. Mishra is not there.
Lordship, Bakalat Nawai. Not reflect, but is maybe Bakalat Nawai.
Are you aware of the observation made by all the lawyers by the Supreme Court, Honorable Supreme Court nowadays, especially criminal appeals? Yesterday also, those observations were issued. Anyway, Mr. Gita, then counsel for the the arguing counsel, Mr. R.S. Mishra, is being disposed of the press for prayer aloud. This time to go.
May Lordship, I mention item number 7, and I on behalf of the Lordship is out of station. Therefore, this matter may be after a week. or maybe of this Friday.
Let's see what is there. Item 7. Then we have yes.
Should say that solution item number 9, my lord.
9.
What of the concern of the other side? There's some talks going on, my lord. So, my lord, if the matter could be adjourned,
Let's better talk it out.
my lord, that is right, my lord. That is right, my lord. Some accommodation, my lord.
On the Mr. within a can concentrate. Appellant submits that efforts have been made to settle the issue between the parties or amongst the parties.
Between.
Parties. 6 weeks.
If it is not inconvenient, my lord, I pray for 3rd of November.
6 weeks. Civil services. Up to 6 weeks. On 3rd of November.
3rd of November.
Item number 1,
My lords. This appeal, my lord, arises out of an interlocutory application where I pray for implement in the writ petition, my lord. And on 2nd September 2024, when the interlocutory application was listed before my lord has passed this writ, my lord. 2nd September 2024, list this matter before any other appropriate bench without me, Justice Lee.
Yeah.
Yes, my lord. I'll just pass on the order.
Okay. Very good.
It is passed in the interlocutory.
Interlocutory application.
Yes, madam. This is the appeal, madam. The reports may not be there. The order are.
Yeah.
Yes.
List the method. Any other appropriate bench. You're one of us. My name.
Deep here.
Item number 2.
Yes, my lord. My lord, the appellant is aggrieved by the Honorable Single Judge's order dated 10th of September 2025. If my lord is pleased to see page 29,
Yes.
that is a impugn order. So just to give a backdrop, I will seek the permission to read para 3, 4, and just the limited paras. Para 3, my lord will see. Brief facts of the case essential for disposal of the case is that APPSC published an advertisement dated so-and-so, inviting online applications from eligible candidates for admission to Arunachal Engineering Service Examination to fill up 166 post of assistant engineer under various works department of the state government. As per the advertisement, yes.
What's wrong here?
Yes. So, my lord, the entire issue is that I'm a bright candidate. I have got 80 out of 100 in the first paper, the paper 1 in the forenoon. But unfortunately and allegedly, I was late and I was not allowed access entry to the paper number 2 that had to commence at 1 o'clock. My lord will see the observation of the learned single judge at para 10. At para 10. My lord will have para 10, page number 33. From the above projection, my lord has it. It may be seen that the examination scheduled on 27 July was in the forenoon from 9 till 11 a.m. and in the afternoon from 1 to 4. As per the admit card, my lord, this is... No, I am
Which
agreed
page?
because my lord... Yes, my lord, the
Page number,
entire...
where you are reading?
I am reading the impugn order, para number 11, forming a part of page 33. So the sum and substance of my argument is this, my lord, that the admit card that has stipulated the instructions no way suggests what is being reflected in the impugn order in my most respectful submission. My lord will see the admit card and the instructions therein. May I be permitted to read the same? The admit card and the instructions, page 66. My lord will see page 66. I will directly draw my lord's attention to point number 5. Entry for candidates into the examination venue will be open from 7:15 a.m. for the forenoon session and 12 p.m. for the afternoon session, and will close 15 minutes prior to the scheduled commencement of the examination, 8:45 a.m. for the forenoon session and 12:45 p.m. for the afternoon session. No entry will be allowed once the gates have been closed. My lord, what the learned single judge has opined is that this particular venue has been read as the exam hall. This is the venue as in the premises to the exam center. And I have definitely entered by 12:45. Otherwise, I could not have completed all the formalities, which comprise of 4 formalities. One is the photograph, the biometric, the frisking, and the calculator check. Why I say so is reflected in my attendance sheet at page 36. At page 36, my lord will see the attendance sheet. My lord will see at page number 86. I will just show the attendance sheet and the time that is reflected. At page 86, my lord will see. I am serial number 187.
Mr. Das, where
Yes.
are you from?
I'm practicing in Delhi, my lord. I'm appearing from Delhi.
Can you please appear physically? It's very difficult.
So, my lord, the
We're not
difficulty is
getting
that...
headed there.
No, I understand. I will endeavor to simplify the arguments in the next 2 minutes. But in case my lord wants my physical presence, the only difficulty is that the
It's not
examination
questionable.
now...
It's not questionable whether we want or not. Very difficult. We're not getting anything.
My lord, the main exam
Because of
is now scheduled...
the technical problem.
Okay, my lord, the main exam now is scheduled on 28th, which is
But
Sunday.
then we don't find anything wrong in the judgment of the honorable single judge.
In my respectful submission, can my lord hear me? Am I audible?
Yes, please.
Yes, I just want to highlight the attendance sheet and nothing beyond. My lord will just see the attendance sheet once. At page 86. I will try to simplify it for my lords. At page 86, at serial number 187 is where I feature the appellant, Kimi Kang. My lord will see the time on the right hand side. It is 1:24 p.m.
Yes.
So
You're
by
supposed to
1,
be there by
1,
1 o'clock. You
So
have
my
to
lord,
take your seat by 1 o'clock.
my lord, this might not be the correct understanding as per the rules instructed under the admit card. As per the admit card, again, I will have to make my lord.
See, what time exam starts?
The exam starts at 1 o'clock, but the requirement
And your attendance
Please.
is of 124.
1:24, 1 minute, 24 seconds. So what I am trying to draw my lord's attention is that the only requirement under the admit card was to enter the venue by 12:45, which I have naturally done so. Otherwise, I could not have walked the 30 yards to the biometric center, completed the 4 formalities, and then got the biometric. Please.
Very difficult.
My lord, this is going to be very unfair to a bright candidate. I have already secured 80 out of 100 in paper 1, and in paper 2, just because of this wrong understanding of the venue and the hall, I will be denied this particular position in spite of being so bright. And the second aspect of the matter is, my lord, the entire substance of the respondent is that there is the statement of some police personnel. I will only highlight the statements, inconsistent statements in the on record. They have stated they have seen me along with 3 other candidates scaling the boundary wall. This is something without any conclusive proof, no CCTV footage. My lord, this will be very unfair in my respectful submission to a bright candidate. Hence, I am just trying to impress my lords on 2 things. One, if my biometrics was done at 1 minute 24 seconds, naturally I have fulfilled the criteria of having entered the venue by 12:45 as is stipulated in the admit card. Admit card doesn't say anything beyond that. It only says that I am supposed to enter by 12:45 p.m., which naturally I have done. Otherwise, I could not have done all of the 4 things and the compliance up till the biometric at 1 minute 24.
Your admit cards require that you should enter in the examination venue before 15 minutes.
I will just read that. That my lord will
15
just
minutes.
permit. Yes,
15
I will just read
prior
that.
to the starting of the exam. So you'll have to be there by 12:45.
My lord, I'll just seek your lordship's indulgence to read it once again. Entry for candidates into the examination venue will be open from so-and-so for the forenoon. Same point number 5, which my lord read at page number 67. I will just read
67.
2. Yes, I will just read 2 paragraphs and nothing beyond. At page 67, forming a part of my admit card, this is the type copy. At 67, my lord has it.
Yes.
Point number 5, instruction number 5. Entry for candidates into the examination venue will be open from 7:15 a.m. for the forenoon session and 12 p.m. for the afternoon session, and will close 15 minutes prior to the scheduled commencement of examination, that is 8:45 a.m. for the forenoon session and 12:45 p.m. for the afternoon session. No entry will be allowed once the gates have been closed. So if I read everything in conjecture, my lord, all of this suggests that the gate to the premises, that is the boundary premises, will close 15 minutes prior. So I have entered by 12:45 without a doubt, without any shadow of doubt, I say, because at
Where do you get it?
Yeah,
Where do you get it?
I entered naturally before 12:45. Otherwise, how
Let
could
us see.
I?
Where do you get it that you entered before 12:45?
At page number 86. At
Or
page
before-
86. At page 86, my lord will see. At page 86 is my attendance report, afternoon shift. My registration time on the right-hand side, my lord will see, I am serial number 187. It is
Yes,
one.
It's It's after one only.
My lord, this is the, so let me just simplify it for my lords. My lord, there is this particular institution with a gate. As per the admit card, I am supposed to enter that gate 15 minutes prior. That is by 12:45. They have nothing on record to show that I did not enter by 12:45. I say I have entered by 12:40.
Exam starts at 1 o'clock.
My lord, that is, so effectively, that is not the requirement under the instructions. In my respectful submission, I have.
When the exam starts, 1 o'clock or after one?
Exam starts 1 o'clock, but sometimes, my lord,
Then-
someone might opt to write the exam, start the exam at 1:05, 1:10. As per the admit card, what is the instruction that? My lord, will just allow me to again read point number 5.
Sorry,
My lord, this is
Sorry,
so basic.
sorry, we feel for you, but then still we feel for you. Try the next exam.
My lord, the problem is the admit card no way suggests
That will
what
be cannot make the things upside down.
But my lord, I just put a question to myself. Just one argument.
Admittedly, you have registered after one. You
My
are
lord, that is
supposed
the
to be there by 2:45, 12:45. Exam starts at 1 o'clock. What more?
My lord, I go by the admit card because that is right now the only regulating terms. It says examination venue by 12:45. I say
Sorry,
that
sir.
naturally, my lord, I have entered by 12:45. Otherwise, I could not have completed the calculator check, photograph, everything.
Yes, sir.
Yes, my lord, I am trying to just establish one point that as per the admit card, the
I
requirement,
think,
please.
although despite the technical gaps, I think we have heard you. We have understood what you want to submit. All right. At best,
Please, my lord.
we'll issue notice today, take it up on Thursday, and dispose of the matter.
My lord, the exam is scheduled on 28th. So that is
That's
the
why.
difficulty that I have.
Or else we'll dispose of the matter today.
My lord, I'll be left remediless after 28th. So in that case, my lord will consider
that's why.
my entire prayer. My whole prayer may be considered. I will just like to highlight another aspect if
Sir,
it pleases my lord.
Sir,
Yes.
it's not comfortable. Let us be very frank. Though we have understood, but it's not comfortable. Otherwise, we'd like to dispose of the matter today itself. Therefore, we're granting you some more time while issuing notice to the respondents. We'll take up the matter day after tomorrow.
Day
All
after
right.
tomorrow. Please, my lord. My lord
Thursday.
will.
That will
But
be
my
better.
lord,
We'll issue a notice today. We'll dispose of the matter day after tomorrow. If possible, please join us physically.
my lord, in
So
that case,
tomorrow, day after tomorrow, you should not, take risk. Can help it out.
in that case, my lord, may this court be pleased to consider my entire case today, the entire relief, and dispose of on merits. I will just address one additional argument and nothing more.
Okay.
My first point I have already argued. The second
Yes.
point is only the observation of the honorable single judge in one of the orders which my lord will find at page 138. This is forming a part of Annexure 5. At page 138, this is the order dated 29th of August 2025.
No, that was the interim. Well, finally it
I
has been
understand.
disposed of. These all
I
got merged
understand.
into this
No.
final order.
I understand.
I
I will just show the
Cannot
contradiction.
fly away.
My lord, just one paragraph and what has been stated in the interim order. One paragraph. My lord will see third para of that
What?
particular order dated 29th of August 2025, forming a part of 138.
Sir,
page number.
page 139.
138.
38.
Yes, my lord.
Yes.
Third paragraph. In response to the query made by the court whether the examination center has CCTV coverage, Mr. So-and-so learned senior standing counsel department submits that he does not have any instructions and he would like to complete his instructions and bring it on record. So what the learned counsel suggests that there is no such record available. Now, the impugn order. The impugn order at para number 11 is where this observation has been made by the Honorable Single Judge. My lord will see at para 10, page 33. The last 4 lines I'll seek the permission of the court to read. My lord has it. The learned senior standing counsel, APPSC, is said to have shown the video footage of the gate leading to the campus of the examination center on 29/8/2025. But since the same is not available to be viewed today, this court is not inclined to enter into this aspect. My lord, why I say this aspect is relevant, because according to the respondent, the only case that they have is that I have scaled the boundary wall. On 29/8,
But perhaps we're convinced that you have entered the examination hall very late or after the exam starts at 1 o'clock. Because your documents, the document shows that you have entered it after 1 o'clock. The requirement is you have to be there 15 minutes before
I
the
completely
exam
understand
starts.
what I completely bow down to
You
what
will
my
not
lord
go
is
into
saying.
CCTV and scaling up. They will not go into it.
But my lord, if I am reading the admit card and the instructions therein properly,
Since
does
you
not
have
say
failed
so.
to show that you have entered prior to 1, we may not insist you to enter with it the much, but I mean before 15 minutes, but after before 10 minutes and 5 minutes also we could understand. We have understood, but very difficult.
I bow down. My lord will consider my writ appeal on merits. I bow down.
Okay, thank you.
I bow
That's
down.
all.
Yes, my lord.
That's
The two. Yes.
Okay. Yes, sir.
Don't find any, other single judge order. And whatever we have stated, here they of course, we were given very short time for filing epidemic.
What?
Also,
Is there any other instances?
not only 4 of them were here. We scaled the wall. So he's filing the appeal. One lady, he also filed the petition. She withdrew.
Where is the statement of police dismissal?
That's in the epidemic.
Yes,
We have given in the epidemic.
yes.
Page 92.
92.
Please, my
For
lord.
police personnel.
With the permission of my learned senior colleague, I may be allowed to show the relevant paras. At page 92, 4 police personnel has given their statement, an identical statement, and 2 others, total 6 statements are there. Two others have said something else completely. At page 92, my lord will see the third line. In the meantime, 3 boys and 1 girl crossed the boundary wall and entered into the examination compound. Thereafter, they were detained and immediately the matter was informed to the control room SP. Now, page 93, identical statement. In the meantime, it's a cut, copy, paste.
Yes.
Page 93, my lord. Identical statement at 93. Identical statement at 94. It's a cut, copy, paste. And what is relevant is at page
Yes.
96. Please.
That's all. Competition starts from the very beginning, from filing of the filling up of the form itself. So it's a competition. It's not a normal examination. So for silly points, only one has to be outstanding. This competition. Competition, no excuse, nothing. It happens. In fact, we all of us bid for it. But I'm bidding for it. We cannot, the rule is rule. That's all. Mr. Das, that's all.
My lord, just to reiterate, my argument remains the same that
Thank
as
you.
per the admit card. Yes, please. I'm so obliged,
Yes.
my lord. Has been very patient.
Mr.
Thank you.
Nishant Das, London Council for the appellant. And also had Mr. Appa, London Senior Council Assistant and Steering Council. APPSC. Assisted by MS and you. The council for the response. This intercourt appeal is directed against the judgment that order taken 10/09/22, right? Was the WPC 390 of 2025 by the Milan by the Red petition. Red petition filed by this will pass the order in chamber, but the writ appeal is dismissed.
May I seek a dusty
This
copy
will
of
be
the...
followed by, this will be, the reserve order will pass the chamber, all right? But writ appeal is dismissed.
My lord may consider a dusty copy for the appellant. A dusty copy.
We're not getting it. What do you mean?
My lord, a dusty copy, that is a copy that is given to the appellant immediately on the passing of the order, the dusty copy, my lord. I'm not sure about the term there. I'm so sorry.
No. The rules are there, procedures are there. Whatever you'll get the order in the evening.
I'm so obliged.
Item number 3.
But this
Challenging the section 6 of urban local bodies.
yeah, we file an affidavit. Why?
They are supposed to file the affidavit. In any case, it cannot be disposed in a day without just hearing.
It's a challenge to the act. So whether filing of any affidavit also.
But beyond the horizons of the separation of the powers.
Subsection 1 and 2 of section 6.
Correct.
What does it say?
Well, here, what had happened, the decision of the State Election Commission, which is a statutory body, now the Chief Secretary, who is also the administrative head, is made the appellate authority. And thereafter, if the decision of the Chief Secretary can also be challenged before the minister. So therefore, this per se, my lord, from our side, we will see that this is violative of the cardinal principle of doctrine of separation of the power provided by the Constitution.
No, this is their, they'll be questioned by the authority once they act under the act.
No, my lord will appreciate one thing.
What's the bar?
No, my lord, law is well settled. There must be a separate standing of a quasi-judicial body and the administrative authority.
Suppose, my lord, what Machiavelli has said once, if the power is vested to one particular person of the legislature, the executive, and the judiciary, there is end of the society. So therefore, all this present, we will have to argue on this matter. Let them file affidavit.
It's okay, but then if you want to argue, we can hear you also.
No, not today. No. Let them come by affidavit. I want to see their
You
stand.
have enlightened us the Machiavelli. So would like to go deeper into it.
Yeah, then
These are
Metro
the-
C0 will come.
These are the oceans.
Yes,
It's a sea,
correct.
right? We have evolved
Correct. That,
75 years.
75 years, my lord, then that
We have
we will have
evolved.
to
Do
appreciate.
you agree?
We will have
You yourself is the author. We have evolved.
society itself is always evolving.
That's right.
We are in a dynamism.
So there is no bar, I think, confer the quasi-judicial authority to an administrative or the legislation.
But two views are always possible.
It's not strictly, cannot bring it to the separation, doctrine of separation.
Still, then, my lord, I'll try my.
No, we'll hear you, but then
I'll try my arguments to convince my lord. At least law is laid down. This cannot. They will file the affidavit.
the doctrine of separation comes into play when there is a separation, the clear separation provided under the Constitution for the executive, legislative, and judiciary. For quasi-judicial body, it is not the doctrine may not be, primacy may not be strictly applied. That's why it is called quasi-judicial body, not the judicial, the judicial authority.
Still, my lord, I'll just request my lord to kindly have a read the paragraph 520, 498, 249 of the Kesavananda Bharti judgment.
No, that's what I'm saying.
That itself.
That's what I'm saying. That is the doctrine will apply the separation of powers. The quasi-judicial body, the authority, there's a huge, not a thin line. It's a much and huge difference between the quasi-judicial body, the judicial body. Not thin line.
May or may not.
That's why it's called quasi-judicial body.
Referred Sunday.
And you may be correct. The doctrine of separation come into play. The judicial and the executive and the legislation.
Gopalan is also someone. Daswami will also be there.
Maybe it's a different topic.
Even those principles which have been laid down.
It's like you are challenging the provision, correct? When the administrative authority or the legislation or for that matter, minister or chief secretary, and confer the power under the particular
Act.
act.
Well, the thin line in this case is that can executive officer be an appellate authority against the decision made by a quasi-judicial body? Because quasi-judicial state election
appeal against
decision made by the State Election Commission will have to be challenged before the chief secretary.
not against the judicial body.
But will not kindly see the second inner line would be the statutory power, statutory
The
body.
chief secretary do not go by the nomenclature. When the power is conferred, maybe a nomenclature chief minister, the minister or chief secretary, select definitely the quasi-judicial body. Authority.
Will not kindly see Article 121 and Article 212. Whatever debate that takes place,
You remind yourself the Shakespeare. What's there in the name? Not Mr. Nitithara, and counsel for the petition. Or the prayer of Mr. And London. additional advocate needed. Further, 3 weeks time is granted to file.
But this operation 27, but we may not be filing our because it's matter of only the. No. In paragraph 11, I have raised the question of law.
That's all, it's a question of law.
Question of law.
But that will not say on the prayer of search, huh? Let this matter be listed on 27, then 2025.
You are waiving your liberty to file the affidavit, right? Yes. Fine.
Will not force them. So, yes.
Good.
Item number 4.
Your Honor, that is item number 4. Yes, NIT is also party of this case. Yeah, and counsel for the NIT is sent.
Jane,
Yes,
will
and I
they,
have to serve my petition.
okay,
It's called
steps. Mr. G. Kato, learn counsel for the petitioner. Submits them, it may be granted sometime. Take press steps for a service of notice upon respondent number.
But 3, 4.
3 and 4. 3 and 4.
Yes,
3 and 4. Praise the Lord. Yes, the to take steps for service of notice. This after 3 weeks. 3 weeks. Sir, additional validity. Spread it for status.
Item number 5 and 6.
May I, Your Lordship?
No steps. Why?
No, Your Lordship, may produce last order dated 11/9/25, Your Lordship,
7, 9.
25.
Ah.
As per the last order,
Submit the business survey. No, thereafter.
so the address has been furnished to me, Your Lordship, so I may be allowed to take the steps, Your Lordship.
In terms of the audit, it is 11/09/2025. It is, no. It is submitted by MSN and Council. She has received the address of the respondent number 4. The appropriate was compared to the addresses the expressions of not in the where they are this number. 4 weeks,
And in item number 6, Your Lordship, same order, but respondent number 5 and 6.
5 and 6. Here 4.
Obliged.
Item number 8. Item number 10.
Lordship, my lord. My apologies, my lord. I cannot take the steps, my lord. I will give it 2 days time to take the steps, my lord.
Where is that? Boro,
MK Boro, my lord.
then concept. This then is granted. This after 4 weeks.
My
2
lord,
days.
highly
You
obliged.
take within 2 days.
I
you
will.
take.
Yes, my lord. I will take the steps
This
today,
day
but
after
my lord, highly obliged, my lord.
Item number 12.
Lordship. Lordship, this file is
yes.
Lordship, from my side, 1 hour.
Then take it after. Then how much will take? How long you take?
According to me, this is not even maintainable.
It's okay. When if it's not maintained, let us here. But then it will require more time. If it's not maintained.
For me, after vacation is perfectly fine. In any case, we should not burden your lordship. Just
Actually, this maintainability is derived from the effect of the case also. And SP Gupta is clear case that FIL has been enhanced, the scope of the FIL has been enhanced by SP Gupta. And nature of the FIL in India. That also, someone who is not has local system filed the FIL for the prisoner. And then lordship, there is one
prisoner.
Yes, Your Honor.
This is for prisoner.
No, Your Honor, that this regarding the local system and maintenance. If there is a public injury in the sense, if
The Supreme Court also it says that PL cannot be a panacea for all things.
Your Honor, that is my judgment is clear that same case, that Assam Parliamentary Secretary Act, the applicant was nowhere having any personal local system. But when it strikes the constitutional validity, then everyone can come, Your Honor. And exactly same way, this above it directly and grossly this strike with the constitutional provision. And because Lordship, legislated act can be either governor act, legislated act can be either president act. When it is president act, then it's okay. But it is governor act. Then when governor act, it cannot be above the supremacy of the constitution. And it is not just
According to you, when the president act, it can be above the president.
Your Honor, that as per this remedy is there. Your Honor. In fact, it is not this above the constitution, but then when it has bill has to be partially placed before the president of India laws, because citizen is detained without reason, and then his reason is not told by the authority. Everything can be done. This has not
So
violated.
let us not have a slightest misconception also that the when the president act is above, can act above the constitution.
No, no, I
Constitution in the top. It is the
supremacy of the constitution.
what it considered.
Yeah, exactly.
Not the general secretary.
It just find the remedy, Your Honor, by assenting the president assent, Your Honor. And Your Honor, especially when this subject matter comes under the concurrent list, there is always condition that it is not free for the state legislation, Your Honor, because there are only already central act that govern the same bill. On that case, Your Honor, it is not free to state legislature. There are three terms on the inconsistency. And if it is derogate the position of the High Court also, because then any law, as per the Article 200 and 221, 201, Your Honor, if any bill, it seems to be derogate the position of the High Court, because if it is derogate the High Court, then bill has to be placed before the President of India, Your Honor. And then President has given back to the government, Your Honor. This is constitutional mandate. And this case is not about the violation of this. It is preservation of the Constitution also. And this has been already discussed in case and about the case also. And when invoking the 82, 83, 84 CRPC, it has always keep the provision of the judicial magistrate, Your Honor. Pro act of the case Ananda Party, when section 82, 83, 84 CRPC is invoked, then provision of the judicial is given here, jurisdiction of the judicial magistrate. It is not direct by the executive magistrate. And first preventive detention was preventive detention of the 1950. It was pre-act of the Kesavananda Bharti case. Thereafter, when Kesavananda Bharti case in the 1973, any law that invoked the CRPC, it is given the jurisdiction of the judicial magistrate. As if absconding order is passed by the judicial magistrate, then it is not mandatorily mentioned. Then it is among to be breach of the this doctrine of the basic structure. Your Honor. This is clear. And moreover, Your Honor, that in 1942 amendment, after the MISA, in the MISA there were many political was imprisoned, more than 12 months, about 19 months. Then Parliament passed that for the chairman of the advisory board, it has to be sitting judge, because if there is not sitting judge, it can be mishandled by the legislature. Legislature is not other than politician, Your Honor. And already we have seen the history.
Are you doubting the integrity of the retired judge?
Your Honor, it is by the mandate. It is not me. It is by the Parliament stated by it is not by me. There, Your Honor, that jurisdiction of the at least jurisdiction of the Constitution and court has to be at least there, Your Honor. If any law, if it comes into the bed ruler, it cannot be. Even if it comes into the hand of the bed ruler, there must be remedy for the innocent person. Bed ruler, I mean, in this, Your Honor, on political way, that preventive detention can be used by the political way also, as it has been used by the during 1973, 74, by emergency period.
That is your perception.
Your Honor, that situation may be done like that, Your Honor, that we have already experienced, Your Honor. This is the discussion that already discussed in the Parliament also, in the 44 Amendment, Your Honor. And so, always, when executive magistrate is not given the free hand, Your Honor, then National Secretary Act, this is came after the Kesananda Bharti, and Kope Posa, it also comes under the, this Kesananda Bharti. This has always given the jurisdiction of the judicial magistrate, so that any absconding and attachment of this property is deemed to be
Some other day. That's more Richard. Right. Is there G. Learning Council for the Dictionary? The hearing the learned counsel for the petition. We find that we're of the view that sometimes we granted to the learned counsel for the petitioner to have more research on the matter as the challenge in this public interest litigation is the constitutional validity of the unmatched this unlawful invocation act. Also, in view of the fact that the petitioner, the learned counsel for the petitioner appears to have arguing the matter on the surface. The looking in that going into the basics of the law and the principle laid down by courts. There's our view on it. By giving you some opportunity. It's nothing like that. You have to ask, not that way. Right. You have some research, go deeper, and one by one, listening. All right. You can't jump from one. I thought that is hearing is not going to take. So if it's not going to take, why you should take that trouble? Mr. Adjournment, learned Advocate General, the state assisted by MS Albasan. It's present. That council for the council's name, this metal will be listed after. When you go second.
There is no 27.
So,
I mentioned one pending petition matter for tomorrow matter.
why? What is the urgency?
Urgency, the petitioner has been placed under continuous suspension for more than
After puja. After puja. When it was supposed to be listed?
Pardon?
Supposed to be listed when?
experiment.
After puja.
Pardon?
We have only a few days. Right.
Lots of like to mention item number 5. I have concentrating from the counsel for the petitioner. The conducting counsel for the respondent due to some personal difficulties is out of station. So I beg to mention item number 5.
You are for petitioner.
Respondent.
Respondent. Yes.
I'm for the petitioner.
Yes.
My lord, may I?
The affidavit has been filed. What is your claim?
Exchange of pleadings completed, my lord, here. My claim is this, my lord,
Pleadings completed.
I'm sorry,
Pleadings completed.
pleadings are completed, my lord.
Yes.
And then there are two issues here, my lord. Number one is that, my lord, when there is a dispute to the land, my lord, whether deputy commissioner was right in referring the matter to the
He's asking for adjournment.
my lord, I'm just saying that what
Okay,
is
then
the,
it's okay.
uh,
Mr. Soetso, learned counsel Your name, please.
M. Lai,
Appearing for
respondent.
respondent number. That's Mr. M.
Three.
Learned Counsel appearing on behalf of.
Respondent number 3,
Yes, your name. Not
M. Lai,
you are appearing for whom?
in behalf of Counsel J. Jin.
JJ, Learned Counsel for the petitioner. What is it? Learned Counsel appearing on behalf of Mr. JJ, Learned Counsel for the respondent number
3.
Respondent number 3 submits that Mr. Gini has some personal difficulty today. Therefore, press for listing of the matter after 2 weeks.
My lord, may I pray for a date, my lord, 22nd, it's not inconvenience to my lord,
After
October.
3 weeks, huh? Praise the Lord. No, Mr. Prayer not being adjourned, objected to by Mr. So and so Learned Counsel for the petitioner. And I agreed to by that this matter will listed on 22nd October.
Obliged. May I lord, one more item, item number 10, lord. Here conducting counsel is responding counsel B. Picha. He is in sick leave. So my humble prayer is for adjournment.
Then, huh?
Yes.
On the prayer of so and so Learned Counsel. Learned Counsel appearing on behalf of Mr. G.
J. Jin.
Dedlik, huh?
And
Is this matter? 3 weeks, huh?
my lord.
Item number 1.
No, my lord, this case has been filed, my lord, against the order passed by the Deputy Commissioner, wherein, my lord, I have been treated to evict from my lord, commercial building. My lord, people come to the page, and
Where is the order?
order in page number, my lord, the 31, my lord.
Yes.
Page number 31, my lord, got it. And I would like to, my lord, take it from the page, second para, my lord. Whereas the earlier, Shri Sas and Sas has also submitted the one complaint that the Sas and Sas to the Deputy Commissioner Capital Complex to inquire into the legal and allotment issue in favor of Mrs. Nabumal H. my lord, and the Bibik Bihar, number Sas and Sas, that Sas and Sas, which was endorsed to the dealer for conducting the inquiry and disposal. And whereas this Honorable High Court order Itanagar Permanent Bench Naragon, WPC number 303, 2004, dated 2011-2024 has directed the dealer Itanagar to dispose of the land between the parties. And accordingly, my lord, that was disposed of. And whereas now complained with the above directions of the district land revenue and the settlement officer has conducted a hearing based on the finding and passed the order number Shas and Shas on 18 February 2025, declaring the land allotment of Ms. Nabum Mali as ab initio null and void, and there is no record to validated her land allotment.
Yes.
Therefore, keeping in the view of the above, Srimati Nabum Mali is hereby directed to vacate the plot of the RCC commercial building situated.
Where is that 18 February? 2015?
My lord, that 18 February that was decided, but that is not with me. Ma.
Then
In
there
the
is the basis. Once they on the
my lord,
direction
that
of
is
this
the
court,
basis,
they have decided on 18 February.
my lord.
Unless you are challenge, you challenge this. This is how can we?
So far, my lord, this 18 February is concerned. Dear my lord, my allotment has been, my lord, declared ab initio and
Yes.
null and void.
Have you challenged them?
My contention is, my lord, whatever that was between the, my lord, two private parties. This eviction notice has been neither on the, my lord, basis of any law, nor in the, my lord, unauthorized occupant act.
No, so this 18 February 2025, right,
My lord,
is against you.
my lord, this
Are
is
you not connected?
against me, my lord.
Then
Wherein, my lord,
have
it
you
says,
challenged this order?
My lord, this is only simply my allotment has been cancelled, my lord.
Once it is cancelled, what is your basis has been removed?
My lord.
Your allotment order has been cancelled and you are not said.
My lord, that
You are
is
not agree.
on the basis of the complaint of the respondent number 4.
Doesn't matter.
But what is the facts behind
Doesn't
it?
matter. Whoever may have complainant doesn't matter. Once your allotment is cancelled and declare what is called null and void.
Now,
So
but I have the different footing, my lord. What I'm trying to display, my lord, this is the land pertaining to the respondent number 4, who has already sold it to me, my lord. And accordingly, thereafter, my lord,
but then
that was transferred.
wrongly or rightly, your allotment has been declared to be null and void.
Fine.
What is the basis now?
Now, my lord,
You have nothing now.
for that, my lord, the
You are stripped of
pertaining to the land,
the building and the land you are possessing on the basis of the land allotment, right?
my lord.
Then, once it is declared null and void, you are not challenging that. What's wrong here?
Because, my lord,
Forget about the aberration of the provision.
no provision
Actually,
has
it's
been.
correct. Actually, it's correct. Once your land allotment is declared null and void, and which you are not agreeing, you are accepting it, then you have to remove. Vacate. You have to vacate the plot.
Now, my lord, this order is passed by the assistant commissioner. Therefore, my lord, in view of this, my lord, I have filed a representation before the deputy commissioner, and that representation is still pending, my lord. What is factual behind the case is, my lord, the respondent number 4 has already sold the land. This is purely, my lord, of private
Yes.
between the two
Heard,
parties.
Mr. Swen. Yes. What is the procedure to evict or vacate direction for vacating this? Where is the 18th February order?
Well, so
But how can the deputy commissioner issue a vacation notice? It's okay, but then where is that order? 18th February. Is the power to obtain the instruction? It is motion. Yes, we have not annexed that also.
my lord, I'm yet to obtain this, man.
So you have filed a
Because, my lord,
representation
this,
against this.
well, whatsoever, my lord, so far the facts is concerned. My lord, since 15 days has time,
But one more thing, how the deputy commissioner can issue this
within
order? You have to follow the law. Is it a public premises?
No.
It's not.
It is purely between the two private parties. The dispute is purely between the two private parties.
Yes.
Therefore, in order to evict to that extent to the eviction stage, in order to reach to this stage, they need to, my lord, take certain procedures of the law. And so far, what is the contention of the respondent number 4 is contending that I have purchased the land, but still 1 crore has not been paid. Therefore, my lord, the record is here with it is that he demanded the 1 crore from me to complete the purchase. My lord will find in the page number. Page number, it is there from page number 27, my lord. The transaction was already done in years 2020, 2008. Thereafter, this element was made in my favor in years 2020. Thereafter, all of a sudden, after the 14 days, my lord, on 2023, the legal notice was issued to me demanding 1 crore rupees as a remaining amount. My lord will find in page number 27.
It's okay, there may be dispute
Purely,
regarding the payment, sale, the transaction, and that we are not concerned, but then since your allotment has been declared
this,
null and void, how do you,
in fact, this allotment was already handed over to me, including the original document. In view of the purchase, this purchase,
see, that too, this order was passed pursuant to the order of this court. Where is this order of the court? It's incomplete. Your petition is incomplete, sir. You have not brought anything. So, Malak, file everybody, bring all those high court's order also. Do we have the high court's order?
my lord, I will find it out. By tomorrow, I will file the arrestment.
This after, day after tomorrow, huh?
Ma-
You bring all the, possible this, 18th February,
My,
or the prayer of Mr. See about the London Council for the business matter. That's been. So it's whenever can bring. Order 18 to 2025.
my lord.
As well as
18 February 25.
and the order of this court.
Development number 303.
Past the order 2011 past the delegation of 2024.
Item number 2.
I cannot pick up this. This is for seeking,
Yes, some reasonable preparatory time.
yes. Make the mention. I put there.
Yes.
The other. Yeah, that.
Item number 3.
Yeah, Lordship. Yes, Lordship, here the petitioner, court is honorable court is a regular service in the RWD department, and now he's getting superannuated on this month, Lordship. So what has happened, Lordship? He had applied for an NOC, no objection certificate for applying of his pension paper, Lordship, and we are aggrieved by the decision of the deputy commissioner of not giving us a NOC. Will issue notice. This is the requirement of vigilance certificate. The no objection. I think there's some cases, if I correctly remember. We have connected that case also, Lordship. This is a no longer raised in the Lordship. This has been settled by this honorable court also, Lord. And occupying of a government quarter should not be a bar for non-issuance of NOC. Where it is. Lordship, I have given in my judgment annexer 12, that's page 57. That's the one of. And Lordship, here in my case also, Lordship, the Department of Housing has given that the allotment which I have occupied is a 4-meter distance away from the government quarter. The page 57, Lordship, this is in the year 2016, WPC 476. This honorable court, in similar cases of matter, there is judgment of this court, yes, upholding the requirements of this NOC. Lordship, there is no such, I'm to my understanding, Lordship. The procedure for
grant of vigilance that which is the circular issued by the in the year 2020, which says that Lordship NOC has to be obtained from the concerned deputy commissioner. Yes. If Lordship, but since here Lordship, in my case, the housing department also has given that the lane which I have applied for my allotment, it's a 4 meter distance from the quarter.
But issue notice that.
Yes.
See, can you also find out? It's yeah, you have not annexed their main judgment also. These two judgment. And there are some judgment you try to find out that this court has passed, upholding the requirements of that NOC from the deputy commissioner. Once it is found to be enforced upon the government. Right. Yes, so then we'll have to, there may be a contradictory judgment also.
In respect to that also, there is an
Last year only this court has passed.
Lordship in that
In the two cases.
in that also Lordship in respect to that
And indeed, at that time, this two judgment is passed in WPC 123, 260. You bring this also. Yes. Page 60, you find out. Yes. What of you? The judgment of this petition. Based on the judgment, only this order has been passed. That's what. Right. And the judgments passed by this court also you find. I think the judgments are passed. Third misstep. Is a learn counsel for the petition. Next, by filing this petition. Challenge the order dated 02/04/2020. What is that order?
circular dated Lordship the page 40, where it's page 39, no, procedure for grantor of decisions. Page 39.
You are challenging this only.
Yes, sir.
With the procedure for grant of next years. The issue. But they are stating that the government officials have no nor has called the amendment eventual enforcement by private person. Page 39. The petition continue. You want 30th
30th of this month.
09 of 20. Issue of this.
Lordship, a fixed date maybe since Lordship.
It's returnable by since MSG and then initial senior all the respondents. No employment notice. No, the requirement of students employment notice is waived. Huh? I will accept. See the Tawa. That's up. West coming of the. Yeah, I don't know whether it's Bombdilla. The Tawa. Then Kandu.
He's settled in Bombdilla. Bombdilla. Working in Bombdilla.
Huh?
He's working in Bombdilla.
You are
From Toang.
so you have encroached the land.
Lordship for that, I have applied for a land allotment also
And Bombdilla.
in Bombdilla.
I think I don't know whether by this order of this court has been taken to appeal or not. Same Bombdilla. Bombdilla case I have detected.
And Lordship here in the dates of
And
the
I'm upholding the requirements.
yes, and there's a report of the verification saying that the
You
land
find out, huh? Both of you find out whether it has been taken to appeal or not. And I now remember. From Bombdilla only one case.
Lordship, but fix that may be given Lordship since Lordship is returned
3 weeks, huh? After 3 weeks. And we find out so that on discernible that we can dispose of the matter.
develop.
Item number 4.
How can we give a direction? You take saplings from you. It's a your base is on MOU.
MOU and subsequent office statement. However, the MOU
If you are based on MOU, you file a civil suit. Yeah.
Because MOU is 4 years.
So, oh, cannot file all the cases. They invoke it. Your basis is an MOU.
Yes.
If there's a breach of MOU, but the many else lies somewhere else.
However, after that, the subsequent.
It's okay whether they're done or not done, but basically it's an MOU.
Yes.
No, it's very difficult. It's not encouraged. We don't assert the power of the authority or the court. No.
MOU is for 4 years.
No. So better is
If after the MOU is ended.
sir, it's sir, it's very difficult. We don't give you a liberty.
After the once MOU is over.
It's in November. You have 2 months. Rush. No. There are certain cases where we simply. No, sorry. Anyway, you've entered into an MOU. It's basically kind of contract. Get it? I mean, executed or whatever. They breach. If it is license, what else?
We have tried everything also, they have office letter for complaints. However, just
That happen. That happen. Then it may be a case of insubordination. Is the authority to take? No, it's not. Sorry. Not for- We are ready to provide any relief as much as possible. The relief which we cannot grant. No. cannot help it out. You can avail the remedy under the civil eviction. You can file a damage also, file a compensation. Can be done. Go for that. Then the appropriate remedy. Not Mr. T gets, huh? What do you say? No, we cannot. Don't do, we are not, cannot convert ourselves in the writ jurisdiction at the post office or at an event manager. Or huh? After expiry of then I can go for that. We cannot today, we cannot. Because we cannot implement a contract. Right? Not our job. Beyond our jurisdiction. Right. It's the T gets then council with the Senate. Having realized that the basis for filing the petition is implementation of the memorandum of understanding dated where? Dated 25/11. This, the, that's all. Otherwise, I can dismiss your repetition of the mentionable, but this may create the hurdles for you unnecessary. It's what administrative advice and that. Therefore, dispose of both.
Item number 6.
Yes.
Well, basically, this case is against the order passed by the manager of the All India Company, whereby my application has
Yes,
been
with the respondent.
My lord, I appear for the respondents.
Yes,
We have filed our affidavit in opposition.
yes.
Last occasion, they sought to file rejoinder.
To
No
dispose of the
rejoinder.
matter if the pleadings are complete.
Yes, my lord, pleadings are complete.
You don't have to file reply.
In fact, my lord, initially, the application was filed on the online basis. And accordingly, after filing of my application,
Mister, are you ready? Mr. Barua?
My lord, I am ready. If I am audible to your lordship, I will be ready to hear this matter, my lord. Assist your lordship.
Yes, yes. Yes.
so my lord, issue is very limited. And I will take the lordship to the page number 14.
Tell us the facts. What is the case?
In fact, my lord, the summary of my case is that I have applied the RO dealer, which RO dealer was for the that was advertised for within 4 kilometers from Arunachal University of the study toward Teju, that is at the Namsai district. And since I am from there, accordingly, I have applied the application. And my lord, my application was accepted. My lord will find that how my application was accepted in the page number 14, my lord. My lord, page number 14.
What is the advertisement?
My lord, since the advertisement was, my lord, I'm not the next day advertisement here. Because this advertisement was, my lord, was only online.
Yes.
At the page number 14, what my lord they said, subject application award of the RO dealer on NS 15 within 4 kilometers from Arunachal University of the study toward the Teju Namsai, State Arunachal Pradesh under ST category, advertisement on 28 January 2023. So, my lord, since the advertisement was not in dispute, therefore I have not annexed the advertisement.
But
We are
to inform you, you have qualified the job not for selection. Yes, then
Thereafter, my lord, I was asked to appear on 4 December 2023 at the Hotel Royal Highness at GNB Road.
that I have read.
In Shukla.
Yes, then what
Then, my
about
lord, on the next, my lord,
you have appeared?
accordingly, I appear and next is in the page number 15.
Hmm.
Here, my lord, we are pleased to inform you that on the basis of the draw of the Lord, selection of the retail outlet for the above location held on 4 December 2023 at the venue Hotel Highness GNB Road, Tinsukia, such and such time, you have been declared as provisionally selected.
Yes.
So I was selected.
Then
Thereafter, my lord may come to page number 16. Here, my lord, I have this magnet. We write a reference to the letter that the 1712 by which
these
you
are
were,
the documents you are. And
yes, these are the
yes,
documents.
then
Then, my lord, kindly come to the, my lord, page number 18, my lord. This should be, my lord, 18, and thereafter, this type out copy is 18A.
this is what.
After verification of my document, I was requested to upload the following rectification and the correct document. Upload and correct the documents. Click here on the such and such that, whereby, my lord, I was directed to correct the document whichever already submitted, and if any documents is to be submitted, my lord. And accordingly, what they have given that notarized by affidavit application as part, and these terms and conditions were given there. And accordingly, my lord, I have completed my document and uploaded to the website of the company. Thereafter, lordship will find in the page number these 19 start. These are my document, which as per the direction of the company, my lord, that I have rectified the certain document, especially this document start from page number 21 is the lease of deed of the land that was executed on 19/9/2023 to show the company that I'm having the land.
These are the requirements.
Yes, these are the requirements as per the.
No, the lawyer has to give this clarification.
My lord.
Is it the requirement? What it is?
My lord, this has not been specifically mentioned.
Okay.
You
have been directed to the progress that you are a award of retail audit.
My duty was only to show that whether I have the possession, I have the land or not. And that land to show that I have the lease of the land with the other person, just to show that only.
And this clarify this. A lawyer.
This lawyer is my lord, this is authorized notary, my lord.
Also, one of it.
My lord, exactly, my lord.
Where it is?
I paid to show the facts.
Where it is the notary? Is it the
My lord,
Notary.
this is the one of the requirement from the my lord.
Why would you say that this is notarized? It's a lawyer. Statement by the lawyer. It's not a notary.
My lord, in which space?
Page 19.
My lord, this is the land. This is OPAR. Details of the land OPAR by my lord. This my lord exactly
Page 19 is by whom?
by advocate my lord.
How?
Because my
What is
lord,
the requirement? Advocate has
my
to
lord,
give the.
my lord, that the company will clarify. My lord, so far I remember because I have come with a
But you said it has been notary. It is a notary. It's not notary.
No, my lord. I'm talking about the notary is in the page number 21, my lord. Deed, this deed of the land. So, my lord, what I'm trying to clarify that, my lord, indeed, I have come at
Where is the interim order?
impugn order in page number 41.
Yes, 41.
41 and the, my lord may come to the 42.
41 is what? This will
This-
inform the visit of
yes.
land evaluation committee scheduled on
Committee
27
schedule,
has been cancelled.
They-
Next
they
date
said-
of the visit. You are requested to be present. Then
Then finally, on the page number 42, whereby, my lord, in the court, this point number 2, my lord, this is to inform you that the land
visited the
evaluation
site offered by
committee
you on
visited
10
the
and found this
offered by
site
you on
not
10
meeting the
April.
required norms as detailed below.
My
Offered land is registered after the date of it.
my lord.
Yes,
That is only the condition, my lord. This land has been offered to me after the my lord, application, after registration after the date of the application. But what my submission, my lord, in this regard is that whatever my application was accepted by the company, and accordingly the company has visited the land and they have verified. And thereafter now they are turned back. What my submission would be, my lord, that they have changed the game. The lease deed with the land, my lord.
What is group D applicants?
My lord, this group the applicants are, my lord, as per the guideline, my lord, is if group
Okay.
A is not able to establish, that only.
Why you are saying that it's changing the rule of the game?
Because, my lord, they have been allowed me. I was qualified in the lot. In the lottery,
When you are required to submit a lease agreement
my lord.
while filing the application,
While publishing the application, my lord, that everything was done. And accordingly, my lord,
then why you have changed the lease agreement after you yourself have changed the game, changed the rule of the game, not by the respondent. The requirement is what? You have to file a lease agreement.
requirement is,
You have, when you are asked to rectify, I mean, to submit certain documents to clarify, submit the documents which have been prepared after the application. Therefore, it is not the respondent authority, it is who had changed the rule of the game after the game had started? Right? Don't apply. That's why I used to say, reborn. Yes, Mr. Barwa.
My lord,
Admittedly, you were selected. Only
yes.
the rejection is on the basis that your lease agreement has been the lease agreement is prepared after
Yes.
the submission of the application. Therefore,
Yes.
your case can.
Exactly.
Yes, Mr.
My lord,
Barwa,
yes.
where is the provision that you can be the ground of disqualification or made ineligible
My
in
lord,
your the brochure or in your guidelines or the township the tender? Yes.
my lord, in every situation, the law of the land is that the deed has to be registered as on the last date of the application, my lord. Now,
Where
if
it
my
is
lord comes, my lord, my lord comes to page 5 of my affidavit in opposition, paragraph 7.
you give this thing, the relevant the terms and the requirements in the guideline.
My lord, that is the reason why,
Seven.
my lord, that was admitted by the petitioner that because when he was given a chance to rectify, he submitted a registered deed which was registered on 19th of September 2023.
Yes. Yes. Then
Thereafter, my lord, when the photocopy was submitted, the photocopy is available with the writ petition, my lord. My lord, yes, the photocopy mentions that the deed is registered on 19th of September, my lord. But when the original was compared at page 21 of the writ petition, when the original was compared with the photocopy, it was found that the deed was actually registered on the date is 1 February 2024 before the sub-register Namsai. That is, if I may read my paragraph 7 in its entirety, that makes the position clear. That with regard to statements made in paragraph 7 of the writ petition, the same are wholly denied. It is submitted that the Land Evaluation Committee visited the land site on 10 April 2024 in his presence, and the minutes of the visit was signed by the petitioner as well. Am I audible, my lord? It appears the link has broken. Am I audible to my lord? Am I audible?
The internet is
My lord, let us postpone this hearing for a further date when I can appear in person, my lord. That would be the best option. My lord. If it's subject to your lordship's convenience. Am I audible now, my lord? Am I audible to your lordships?
ask all of them to come.
My lord, can we come physically, my lord, on another date?
You Argo, what's the in voucher? What's the requirement of submission of the lease agreement?
My lord, I will
So-
present the same before your lordship in person, my lord. May I pray for that? Let us.
Sir, you tell us you have filed the affidavit. You have referred
Yes,
to the para 7.
Yes, my lord.
You just
My
point out.
My lord, the deed has to be registered, my lord. That is an affidavit. I'll download it from the website since it has not been enclosed by the petitioner. And since that is a crux of the dispute, my lord may have it on another date, my lord, kindly. Because the internet is also not.
Also, Mr. So and Borwa, that the counsel for the respondents. Due to technical glitch of better, the hearing could not be completed. This after 3 weeks. As part of
My lord, on 31st, if possible, my lord. 31st of October.
Mr. Takov, no affidavit.
No, your lordship, they have filed
Saying what?
saying there's nothing, your lordship. They are simply saying that order does not says about prescriptions of any allopathic medicines. Apart from that, there's nothing.
Leading counsel is out of station.
What can we do? Is to be done.
In that regard only, your lordship, we are seeking clarification, at least issue some specific order whether we can, while discharging the emergency duty, your lordship, it's in ground reality, it's not at all possible, your lordship.
Well, they listed, the affidavit.
Affidavit, your lordship, they have filed on. No, wait, your lordship.
1 and 2.
Yes, your lordship, 1 and 2. Your lordship may see para number 7, your lordship, in the affidavit nominations.
It's very inconvenient. Yes, madam. How do we? Turn on the page. What is this? That's wrong. All these people also. Yes, which paragraph?
Paragraph number 7, your lordship. May I, your lordship?
Yes, yes.
That with regards to the statement made in para 7 of the writ petition, the answering respondent begs to state that there is no infirmity in the impugned order dated 18/12/2007 issued by the Mission Director NRHM Government of AP. The language of the order is plain and clear, wherein it is stated that all the Ayush medical officers are maximally involved to deliver health services to the population. There is no bar under the law that the Ayush doctors cannot be deployed in emergency duty. They can be deployed in emergency duty and may discharge and deliver the duty within the scope of their own discipline. In the impugned order, it is reiterated that the Ayush doctors are asked to perform emergency duty, but there is no mention of prescription beyond their
What is
scope.
the requirements that the guidelines has to be provided?
Yes, your lordship. The petitioners are,
As
As per the-
doctors.
yes.
Ah.
So as per the act, we are bound to practice within our own system of medicine, your lordship.
Obviously, you are practicing.
Yes, your lordship.
Nobody is stopping that.
So
With only you have been engaged. in
we
the
haven't
emergency
engaged, your lordship,
and
but
the- what is it called? Casualty. Huh?
yes, your lordship.
What do you want?
So our prayer is that, your lordship, while discharging emergency duty means, your lordship, reality, your lordship. Sometimes we are compelled to prescribe, your lordship, without any order, your lordship. Because even the
What's
duty rosters,
requirements of passing order? How can you be, if you are a Ayush doctor, how can the authority pass an order to prescribe allopathic medicine?
your lordship, here,
Do you have the license to?
no, your lordship. That is what, your lordship, we are seeking.
Leave up to that. Don't prescribe allopathic medicine.
But the problem lies in the given situation, your lordship. In many of the PHCs, CHCs, your lordship, we have annexed a status report also. Say, for example, in Mukto, there are no MBBS doctors, only Ayush doctors are there, your lordship.
So it's up to them. You just don't practice beyond what you are not supposed to. It will be dangerous.
And we have been,
And the authority can just prescribe you. I mean, since you have been engaged in the emergency duty, they cannot allow you to
but we
prescribe
have,
allopathy.
yes, your lordship, that is what we are seeking clarifications. And in my
Don't
petition,
prescribe. It's the risk of the authority.
exactly, your lordship. So
Don't
now,
prescribe. You just do your within your the hobby, within your limited the profession.
now problem lies, your lordship. Suppose while discharging emergency duty, your lordship, in our system of medicine, we do not have any life-saving drugs. Emergency means, your lordship, any casualties. So
Don't we? How can you prescribe? And how the authority will ask pass an order
then, your
to
lordship,
prescribe the allopathy when you are not.
then your lordship,
And you are not. Sorry.
your lordship may see even
Anyway, we'll take it up when it's. We may suggest them something.
lordship, because these petitioners are,
Be fair. I'm not saying that you are unfair, but your petitioner be fair. Are you really in the Therefore, not interested in, I mean, not in the emergency duty you are taking.
Exactly, your lordship. We are not denying, we are not refusing in rendering emergency duties.
No,
Our prayer is that,
they
your
don't
lordship.
prescribe allopathy
Yes, your
medicine.
lordship. So in order
You
to,
cannot, you cannot.
lordship. So we are not against the emergency duty. At least duty have it, your lordship. Now what they have done, they have made a single duty roster.
Emergency means what? There cannot be emergency for
Casualties, your lordship. Yes, your lordship. So there has to be parallel roster for that also, your lordship. That they have not done. They have simply placed all the IUS doctors. No MBBS doctors, your lordship. In the duty roster also, it's a common, it has to be parallel, lordship.
Where it is to be prescribed, and which rules?
Because if it is a common roster, your lordship,
So under which, from where you are submitting?
that we are praying for parallel roster, your lordship. At least.
On what basis? What is the basis?
Because MBBS, the treatment which
No purpose. I mean,
we have highlighted everything in our representations, and since 2008, your lordship, we are submitted several representations that has not been entertained, and only file noting has been done. Latest 2024 also we have submitted memorandum. The petitioners have submitted memorandum, your lordship. That has not been.
And MS and consent for the petition. Mr. Swain, learn consent. Pleadings are complete. Next para. Mr. Swain, then consent appearing on behalf of Mr. Itago. Then it's maybe consent at the so Mr.
Which operate, your lordship. We did interview your lordship for disposal.
Well, this one, what's there?
Yes,
May dispute the reposition. She cannot not to engage in emergency.
lordship. Lordship, obliged.
Endeavor shall be made. Disposal.
Lordship, obliged.
Item number 8.
Lordship, this matter, local pleadings are complete. So this matter may be posed for execution.
What is the
Matter for dealership, RO dealer.
And MS,
He comes in.
he comes in that concept for the petition. And MS,
May I, Your Lordship?
ah,
Am I appearing on behalf of DSGI and Kato?
My lord, I appear for the respondents, IOC.
Who?
My lord, I am appearing online, my lord. N.
Name,
Barua. N.
Ah.
Barua for the N. Barua for the respondents, my lord. IOCL. My lord, the video is disabled, I believe. Let it come for admission.
Yes,
Lordship, may I please, Lordship?
yes.
Lordship, here, Lordship, department are yet to their affidavit of
Is it required? Can you compel them? The respondent number 1.
Next process, my lord, that regarding the IOC dealership, it has been put to challenge by the petitioner. My lord, they are not challenging the procedure as such. Now, I'm representing respondent number 7 and 8. Respondent 7 is a PST, my lord, who has taken a lease of
lease of the land from the respondent number 8. Respondent number 8, the person who is a permanent resident of the locality. Now, I am in possession of some area.
You are for respondent number 7.
7 and 8 both. I am the beneficiary. Now, in this only theory and yes, and respondent number 7. Yeah, respondent number 8 has filed. 7 is not necessary. Yes.
So the government is not required. Affidavit in the opposition on behalf of respondent number 1, 2 and 7 and 8.
7
you are-
Yes,
8
madam.
already filed. 7 is not necessary. 7,
1, 2 and 8 have already been filed. Okay. Ms. So, then council, then state council. First board, first board. Filing affidavit, for sometimes to file affidavit on behalf of respondent number 6. Submission. 7 and 8. It's after 3 weeks.
Some observation will be made, since they are not filing, that in the absence of
Why we DLS. Why DLS? DC there, DC is fine. Anyway, considering the issue. Forming the state petition. Appointment, selection of dealer.
IOC,
IOC, what petrol or something. What it called, selection of dealership.
IOC retail dealership.
Selection of retail dealership. Around.
IOC, Indian Corporation.
Internal Corporation. Come on. Reversal movement. Not fine. We have press number 6. Even if it is not filed, we'll dispose of the matter. DC has filed. DC is saying so. He doesn't have any authority. It's your subordinate. But it's correct. Issued or even.
Lordship, I have not received the copy, Lordship.
Huh?
I have not received.
Which one?
Filed by the DC.
What is the copy?
May I pray then, let it come for admission hearing.
This for admission.
Item number 11 and 12.
Yes, my lord. What is, my lord, praying for implement of the respondent number 8 and 15. My lord, after the issuing of the notice, we come to know that the respondent number 8 and 15 is already died, my lord. So, my lord, in place of the respondent number 8 and the 15, their legal here may be arranged in their respective place of the respondent number 8 and 15.
Substitution.
My lord.
Yes, any objection? No. No objection. Heard Mr. C. Modi, learn counsel for the petition and also heard MS. Who is 1, wife 2? Serially. The P. Sangita, then statement correspondent. 1, 2, and 5. 5 and 4. Huh? 4 and 6. Then
I'm for the private respondent, only private.
Who?
Respondent
number?
Respondent number 7 to
60.
7 to 6,
15, 7 to 15.
7 to 15.
This is an application seeking substitution of the respondent number 8 and 15. By the applicants, by the applicant in the connected writ petition with WPC 591 of 2020. I was saying replacement.
It should be, yes, ma'am,
Substitute.
ma'am.
It is. Still, what is the length about?
My lord.
What is the dispute about?
Well, this what is this land ownership certificate has been issued to all the private respondent by the deputy commissioner. So I am questioning about the ownership of the land certificate.
The applicant. By the writ petition. When the connected writ petition. When the WPC 591 of 20. Challenging the order passed by the Deputy Commission of Arlo, the 67/2019. And subsequent land ownership certificates
Mallet.
issued to the private respondents on 18/2019. The petitioner added as many as how many? 8 to
8 to 15, madam.
how many persons? As many as 9 persons. 9. During the pendency, the respondent number 8 and 15.
Madam.
Expired. The then concept. Substitution. Yeah. Paste in, number 8 and 15. So and so. IAS skills. Now the expert. Yes.
Well, yeah,
Three of the order pass. Huh?
Ado, my lord, in place of the Lowland, yes, yeah, Ado,
Not lowland.
my lord.
You have said lowland.
Ado,
You have
my lord.
written lowland.
This should Ado. Ado, in place of Lowland, my lord. The Ado in, I don't know, Ludo
Yes,
Lowland.
you have written lowland. In prayer person, you have written lowland. It's lowland or ado?
Ado, my lord.
Wife of late Kirja Madhu.
But you have written lowland. Place then.
My lord.
Prayer
What?
person.
But they,
Right.
Ado.
Then in the other past century, the eyes should pay the concept of Muslim. That's all. You represent the street.
Item number 13.
Which is, matter pertaining to tender, madam.
Affidavit in reply not yet filed. Don't want to file.
I want to file.
Huh? No. The midterm well, yes. Well, that
The polyamorous affidavit has been filed by the petition respondents. I may be given some of
what is the work? What is the work?
work is for construction of upgradation of Yomsa ADC headquarters to Lirmova EAC headquarters.
Why we don't allow to construct the work?
Just for a reasonable time, a reasonable time maybe.
At the last time.
Just my lord.
No, my lord, I'll be objecting that, my lord. Because, my lord, when this petition was moved, my lord, situation was created such a way that the petition was, my lord, restrained to submit his tender document.
Exactly.
Number one. Then number two is, my lord, the executive engineer, my lord, there is a personal allegation that he remained absent for 2 days, my lord. And that was the crucial time to decide, my lord, tender document. My lord, we have filed the affidavit on 25/8/2025, my lord. Now we are in 9 months. Almost it's going to be 1 month. Still they have not filed any.
Further 1 week.
No, my lord. Then, my lord, your lordship may kindly modify the interim order.
You please file it so that we can consider.
But ultimately, my lord,
That's why it is listed for order.
last
We could have got it listed in the admission.
last time,
Then we could have disposed of them.
my lord, last occasion also, my lord, my brother-in mother make a prayer. Then it was made clear to the Honorable Court, my lord, that never shall be made, my lord, for final
Yes.
decision, my lord.
But we'll give him a last chance.
But only problem is, my lord,
Final
it is ever my working season, my lord.
Yes, what is it? After immediately reopening. Give them, fix them. Reopening.
Or your lordship may allow us to, my lord, open the tender at least, my lord.
What is the,
Your lordship totally stop the matter process, my lord.
have you participated?
My lord, no, man, he
This is
cannot.
the case, my lord. Exactly.
Okay.
I am
He has not submitted a document, my lord.
Made sincere attempt to obtain summons with along with EMP on so that before they do the election. That election will be considered and we will be considered and big documents not be accepted.
That is totally false, my lord, incorrect. That is only 2 grams, my lord.
But normally this court, no, not to prepare with all this
My lord.
development activity. Why don't you immediately file an IA? Anyway, next. Or immediately reopening. Wait for some time. 21, we'll fix it up 21.
My lord, that's why, my lord, slight
One or two
modification,
more,
my lord.
We'll say that we'll list it for admission hearing in the meantime. You are granting a last chance.
Yes.
Or your lordship may add one more thing, madam. Your lordship may kindly allow us to complete the process. We will not, my lord, about the work. Let process be completed, madam.
Have you gone through the affidavit?
Yes, no, my lord. I'm sorry, my lord.
Even after 1 month.
My lord, admittedly, the affidavit.
See, interim order was passed on the ground that you have not been allowed to
Yes, correct. That was.
submit the EMD and all those bits. And the statement based on your submission and the statement of the junior engineer.
This is my case.
So they are saying that it is not the fact.
My lord, even matter of the police.
Next is just the revision.
Eviction, my lord. I'll come with the
What is the stage of this process?
Process, my lord. Technical, my lord, evaluation, my lord. But financially, my lord. Your lordship stop the process.
I'll come with my
So, your lordship may allow us to complete the process. We will not award at least.
I'll come with my some
Process
document, relevant document.
Once in this process, he has not participated. Could have asked for participation.
We have not been given, my lord.
No, that time it is.
No, my lord. That time already it was open, my lord.
Anyway, wait for some time. Let us not complicate the matter.
21st month. 31st month. In the meantime, we'll file.
Immediately reopening.
Yes.
My lord. That's why, my lord, your lordship may kindly allow us to the process. We will not give the award, my lord.
No, we'll discuss them on that.
My lord. Yes.
No, that's why we said we'll grant him 1 week or 2 weeks.
2 weeks time.
On the prayer of Mr. M. Katolan, counsel for the petitioner, but the 2 weeks time is granted to file within a period of
2 weeks.
2 weeks from today. As a last chance,
Well.
just say, this and Mr. Swain, Archana Bhavnana, and said that
Madam.
are present. And they together instead of 21.
21.
As admission,
Admission hearing.
for admission.
Correct. In the meantime, madam.
In the order may not be.
Item number 14.
Item 14 and 15. Also tender method, supply of material under Manrega. There is a stay order on operating. And
So why this is this orders?
we have filed our affidavit, madam.
So,
My lord, I have just received it this morning. Let me just go through it. I'll see if necessary. I'll file it.
Mr. Oh, Padman, counsel for the petitioner. Mr. Both of you have filed?
Yes.
Mr.
Never have filed, but
Friday is always busy.
no, man. But I was
Friday he's off there. Taken from every duty. Off there.
I'm okay with it.
Next week.
Next week.
This is the last, I think.
I'm okay with that.
But I said, at this stage, both the cases.
Yes, ma'am.
Together.
Yes.
Mr. N. Bharat, medicine. MS, in both the cases. Submitted my Mr. Father, And as a that was that is about 23rd.
Item number 16.
Can I hear this matter? Can we dispose it out?
Sir, I want to speak now.
Then we will speak at 2 o'clock. We'll allow you to speak at 2 o'clock. All right? 2 o'clock. Or are you seeking some adjournment? Are you ready to argue the matter?
Yes, sir, I want to.
It's 1 o'clock. We need to take some lunch also. So, right. We'll have to eat also. Survive. Right. We'll resume at 2 o'clock.
Item number 16.
What is the other side? You are petitioner in person. Just some issue. Where's the respondent? Where's the respondents?
I'd like to mention one matter. My lord, by mistakenly, I mentioned this matter in court number 5.
Which one?
My lord, I like to mention.
You make it a mention tomorrow.
Tomorrow. My lord, it's for tomorrow.
It's over now. Tomorrow.
Can I speak? My case is career advancement scheme. I was appointed as the professor.
No, sir, I have read your brief. That's
Yeah,
corrected. What was my view?
Yeah, okay. On the date of interview, but I could not get the eligibility date. I could not get the eligibility date. I could not get the appointment on the eligibility date. Eligibility.
Appointment?
Eligibility. I could not get eligibility.
And it will be important.
Yes.
So what should be done?
I should be eligible for appointment as a professor on eligibility.
No, it's not a law. It's not just because the moment you become eligible,
Yeah.
you should be granted promotion. It's not the law. Otherwise,
They have given, sir. Other teacher has filed grievance. Other teacher have filed a grievance. They have given. They have given to them.
by whom?
University.
By the court.
Yes, just
By the court.
University has given a 22%. They have given, sir.
Same on the same day, which you are seeking.
No, next promotion. Next.
It's something we don't. It's in the court. The court is the law is very clear. The moment you become eligible, it doesn't mean that you will be given the promotion. There's a procedure is there. So anyway, whatever you are for.
Your Lordship, I'm appearing for DSGI and Kato.
And then who is for the university? Who has to appoint you?
Rajiv Gandhi University.
Huh?
Rajiv Gandhi University.
Who represent them? Secretary, University Grant Commission, Ministry of Human Rights, Vice Chancellor, Trump Chairman. Who is appearing? Registered Rajiv Gandhi, HOD in Federal Education.
Sir, they have given order. University has given order. University has given order.
What order?
Eligibility. All the appointment have made from the eligibility, not date of entry.
It's very difficult.
University has allotted, sir. University has promoted a person to every person.
No, if they have promoted illegally and against the rule, there's no negative equality. There's no concept of negative equality under Article 14 of the Constitution, right? Any notice has been served or what?
They have issued the active also.
Why these respondents are not appearing? Why the university is not appearing?
No, sir. I did not know.
We don't see like this, sir. Appearing for the university.
University.
Yes, who appears for that? This is what? Consider grievances submitted faculty members. The following faculty members have been submitted. Grievances requested to ratify the date of promotion. It has not been granted. You just look at next page. You have that.
No, sir.
It has been mentioned, UGC is mentioned.
I filed a case in the court. That's why they did not accept my.
Where is your case?
Sir, I have filed a case on here. They said they will do. Court will do. Sir.
No, this has not been granted, sir. It has been mentioned in the promotion recommended by selection committee considered according so and so. The report decision of the selection members of the above mentioned faculty are kept in BC office. Decision. You see the decision. The EC perused the matter and suggested to relook it with all the related documents. The members suggested for a committee to examine the matter and place it in the next EC. It has not been given. They have not been granted. They have just only mentioned that they have placed these grievances. That from the date of eligibility, they should be given. Therefore, this should be.
They have promoted, sir. They have promoted number 1.
Where it is?
Page number 4. page number 4. Page number 4. EC dot 661.04. Following faculty member have been submitted grievance and requested for ratify their date of promotion on the eligibility date. Yes. Number 1, Professor Quorum.
See, then you come back to this next page. These all 9 persons, huh?
Yeah.
You read this next one.
Yeah.
Next page. Bottom. Next page. You read next page, sir.
Member proceed to ratify that same.
It has mentioned in UGC.
Yes.
Read it.
Yes, sir.
Then you read next page. Decision. Page 6, you read the decision.
University Department Data Expert Assessment of Promotion was as well.
Not that the EC perused the matter. This is the decision of the executive committee.
EC pursued the matter and suggested
To relook it with all relevant documents, the members suggested the committee to examine the matter and place in the next EC. There is a question of promotion. It is under consideration only.
Sir, they have got
When?
last month.
Where it is?
I shall bring some. I shall bring.
Number 1, it's very difficult, sir.
I shall bring, sir.
And you have not filed any additional affidavit as yet. Who has to file the affidavit? Who is for the university? Who is the council for university?
So we are performer responding. The men responding are 2, 3.
Although matter is taken up for hearing today, none appears for the. No. Heard Mr. What is this? Your name? Satish Kumar, petitioner in person. Mr. Mr. No. Although the matter is taken up originally. Come on. None appears for the petition respondents except MS so and so, who appears for Mr. M. Kato, then at DSUN. And to submit that Mr. Kato has some personal difficulty. Huh? What is your submission?
So we are performer responding, sir. Your worship.
But then you will have to appear when you are made a party. Or may need some assistance from you. To submit that since they need Mr. Kato is appearing on behalf of performer respondents. The hearing of the argument, the submission on behalf of respondents. On 05/06/2025, Mr. R. Nabab, then a standing counsel for Rajiv Gandhi University. Press for filing an additional affidavit in the mention. Mr. Howard. It's fine, huh? Is there the petitioner in person submits that on the submits that by placing some minutes of the meeting of the 61st Executive Council, Rajiv Gandhi University, submits that all similarly situated persons have been granted the promotion from the assistant professor to professor from date of eligibility. However, case of the petitioner has not been considered. Matter is sub judice. This is your submission. Next paragraph. Perusal of the copy of the meetings of the 61st Executive Committee held on 28/11/2024. Reflects only the grievances and request for ratify of their date of promotion under CAS on the date of from the date of eligibility instead of date of entry of the 9 professors of Rajiv Gandhi University, right? The decision process grievances appears to be under consideration and no definition of promotion date of since the petitioner in person insisted that the promotion had already been granted pursuant to the 61st meeting of the Executive Council, that is 9 professors, excluding the petition. Final decision and the appointment orders granting promotion, CAS promotion. What do you call it? CAS promotion. Career advancement. Career advancement. Granting promotion from the date of eligibility, the CAS. To those above 9 persons. The next date. Or not before the next date. But go after 21. Within 1 month. You just bring or file the affidavit, whatever promotion order and all those decisions, and this is under process according to this. It's still under consideration. It has been finalized. So, you are saying that that has been finalized. Promotion has been granted. Yes, sir. Yes, sir. Yeah. Yeah, is paid for this matter on when? Last month. Huh? Last month they have got. Huh? Last month they have got. Anyway, I have directed you to file the bring on record
by something that you have filed the case in the court and they will give.
I have passed the order, you collect the orders, huh? Have you understood? You have to bring all those appointment orders, promotion order and a decision by an affidavit.
Yes, sir.
Right,
Sir.
then we'll next consider. You inform, kindly inform Mr. Begum. File affidavit, additional affidavit is granted earlier and then to appear on the next day. Kindly inform, huh? What did you just last time there? Request is being made. No, the MS so and so Learned Council is requested to inform Mr. Regum to appear at London Standing Council, Rajiv Gandhi University, to appear on the next day. And then to file the additional affidavit as read by him on the last occasion and to appear for hearing, appear on the next date. Just inform him. This on when? 21st October. 21st.
Obliged.